So hi everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law, and today we're talking about company law for the FE1 and my tips for 2025. So I have some tips and then we're going to talk about exam papers and all of that. So I always say when I'm teaching company law is to understand the foundations, understand the rationale of company law. So understand separate legal personality and limited liability, those key concepts derived from Solomon v. Solomon. It's just so basic to know that, and to know when the corporate veil will be pierced. You're never going to be asked that directly. You're going to be asked around when the corporate veil will be pierced and those scenarios, rather than being asked by this, rather than be asked about the separate legal personality. So just have a basic understanding, but understand that you're never going to be asked that, because no lawyer in the world has ever been asked, can you explain separate legal personality to me? Like, everybody knows what that is, even in public. So it's the exemptions are very, very important. My second tip would be to know your Companies Act inside out, upside down. I don't know, I've been saying this for the last 10 years. You need to know literally every single section. You cannot get away with skipping on that. You need to highlight sections. You need to know, like, section 158, 819. I'm trying to think. Just all the important sections. If you don't know these, you're not going to pass the exam. You need to obviously be able to remember case law, which is an interpretation of those sections, and also, like, previously were there before the Companies Act was enacted in the 2nd of June 2015. And yeah, so try and do your best to remember case law. I know it's really hard, but you really need to remember, certain cases like O'Neill v. Ryan, these air farming, the Fife's decision, all the different decisions that come with, being restricted as a director, all of them. And be very, very good at applying the law to the facts. So always remember, you set out the law, then you apply it to the facts. I would say a big one is understanding the doctrine of ultra vires. A lot of people get very confused pre and post Companies Act. So just remember, the doctrine of ultra vires was abolished for some companies, like those under parts 2 to 15 of the Act, but it still applies to DAX, it still applies to PLC, and be sure to cite relevant provisions like section 38, 39, 40, and cases like Ashby Railway. If you're giving a brief overview of the genesis of ultravirus, don't go over the top. Directors' duties are just pivotal to this exam. You have to understand them inside and out, what they are, who they're owed to, good faith, no conflicts, care, skill, and diligence. It's guaranteed to be asked. Focus on section 228 and its fiduciary nature, avoiding conflicts of interest, all of that, and cases like City Equitable Fire Insurance give you the right context for this. I already mentioned the corporate veil. A big one the examiner loves is fraud, or agency, or evasion of legal duties. You have to know these inside and out. Have a basic understanding of the advantages and disadvantages of incorporation, I would say. You really need to understand corporate authority, know the difference between actual and ostensible authority, using cases like Freeman and Lockyer and Kett v. Shannon. Understand warning signs around reckless and fraudulent trading. Know your section 610 and 611 really well, and know the difference between them. Reckless trading involves negligence, but fraudulent trading has an intention to deceive. So look at cases like Heffernan and Kearns and Kelly's Carpet Drum. And yeah, looking at the exam papers, so I look at the exam report from March 2024. It seemed to be particularly scathing, actually, and this has been the trend in company law, especially for the last few years. The examiner is particularly disappointed. Like 58% of people are passing, but that's still a lot of people failing the exam. So yeah, in March 2024, it was an essay around describe and discuss how a floating charge is different to a fixed charge. That question is very popular, very well answered, is asked and has been asked many years, time and time again. Question 2 was a problem question relating to the law for the removal and appointment of directors. I would say this caught out a lot of people because it's quite technical, and like when I was looking at it, when I was giving grinds, I was like, wow, there's actually a lot to this, because not only do you have the notice periods around convening an EGM, you also have, to look at the rights of shareholders. You also need to look at the resolutions that need to be passed. It's quite a difficult question, so I would say hardly anybody did that, just because it wasn't so cut and dry as questions usually are. Question 3 then was a separate legal personality question, and it was around the director's behaviour or fraud. Question 4 was around was an essay question around director's duties, and I say people did very well in that, because that's also been asked many times. Question 5 was a problem question around protecting the minority shareholders, which was also well answered. He said question 6 was also very popular, which was a problem question around strike-off, dissolution and restoration. I did that in the last chapter. I would say this has become very popular in the last few years, strike-off and dissolution. Also be careful, the law has been updated, and I've done so in my ebook. Question 7 was a problem question around restriction. Again, that's asked nearly every single year, and I'd say people did very well in answering it. The case law is very straightforward. And the last question was a problem question around the registration of charges. Again, this has been done many times. You have to be very careful in knowing the difference between a registrable charge and a non-registrable charge. Then looking at October 2024, I just updated my 2025 notes with these, but I think it was a fairly reasonable paper. The first question was an essay around section 31. That was fine. It was an essay. The second question was setting aside transactions, problem question. And obviously you're advising the liquidator there. Question 3 was that usual essay question around ex debito, just to take in a wind up order. So it's around debts. It's a nice essay question, it's been asked before. Question 4 then was 2 questions around ultra-virus and corporate capacity. Question 5 was also a problem question, director's duties and the remedies available to the company. That was literally been asked every single year. It was even asked on my FE1. Acting honestly and responsible as a defence to section 819 was the essay question. And question 6. Question 7 then was around the enforceability of charges under and then there was book debts that weren't registered. So again, that's not a registration of charges question, problem question. And then the last question was an essay around the protection afforded to minority shareholders. So that was a fine exam question. Sorry, that was a fine exam. I would say March was slightly harder because of that removing of the director and all of the corporate governance that came around that. So yeah, that's company law for 2025. Best luck with your exam in March if you're sitting it. The 2025 ebook is now updated, and I'll see you in the next one.